I emailed out a handout a couple days ago, but I'm going to go ahead and post the handout again here. You can download it. It's going to be in your chat right now. There it is. And Stan, go ahead and.
Oh, hello, everyone. Thanks for having me. Can everyone hear me okay? Okay. Well, thank you for having me. I appreciate getting the opportunity to speak to the Kansas Self-Storage Owners Association and the members. I trust all is well across the Sunflower State today, but wanted to take some time to go over the status of the law at present. It appears that there have been not many changes in the law in Kansas since we last met, but I do want to talk with you about an issue that I'm seeing in more and more commonly as I go through and talk with people across the state, and that is an issue that comes up with regard to the fact that technology has outpaced the law. What do I mean by that? Well, let me see if I can explain what the issues are. When we first started, I first started working with the self-storage industry long ago. The first thing we did was prepare a carbonless form. This was our first step forward on technology. It was a means of getting 2 copies at once, and we were at the cutting edge of technology. Well, not too long thereafter, the computer and the internet changed our lives. It changed my business. I know it changed yours. We now have remote paperless transactions. We have software to manage the business, including rental agreements and lien sale procedures. A lot has changed, and for the good. But the problem is that our self-storage law has pretty much remained the same for 40 years. So even though we've had a few upgrades for emailed notices and such, it's essentially the same law as it was in the carbonless era. And that's been something of an issue for us. And what makes that important is that we have to continue to apply that law, even though the technology has moved beyond. And so what I'd like to do today is go through a few things that needs to be remembered, that you still need to be dealing with as you take care of these issues. And I'm having a little bit of a technical issue at my end. Can everybody still see the shared screen? We're not seeing the shared screen.
No.
Okay, hang on. Let's see if we can get it back. Okay, now are people seeing the shared screen again?
No.
Still not seeing it.
Green button at the bottom, the share screen button.
Yes, and that's what we're using. Hang on, let's try it again.
Are you using multiple screens?
Nope, just one. So hang on here. Any luck so far?
No.
Still not coming through. Okay, hang on, folks. I don't know what has happened to my presentation.
There we go, Stan. You're good.
Are we on now?
Yes.
Okay. Well, I'm going to wing it because, believe it or not, I can't see it, but as long as you guys can,
Okay.
that's all I'm concerned about. I can do it this way. Okay.
So one moment. So you can see your screen. The presentation isn't showing up on this screen. But what I'm seeing is a Zoom window open.
Okay. Hang on here.
Okay.
Yeah, we're still having some technical difficulties here. How about now?
Okay. Yep.
Are we
See
up now?
Yep.
Okay, guys, I'm sorry. I'm not sure how it disappeared off my screen. Okay. Well, then let me go forward. So the bottom line is, the issue is we are in a 21st century business using a 20th century law, but it still applies. And that's critically important. And it's also important because it doesn't work for us doing business in Kansas to be complying with somebody else's law, whether it's California, Texas, whatever. It has to be Kansas law. And we all know that if we don't comply with this law, bad things happen to us. We lose, a means of getting out tenants easily who aren't paying. We lose the opportunity to at least recoup some of our money back through a lien sale. And we lose the right to a lien sale altogether, and if we violate that, bad things happen. You can open yourself up to damages and punitive damages, and really horrible things happen. So the critical thing is to know is you've got to comply. And that's why much of the software that you can get out there comes with a disclaimer that looks something like this. Be advised, any sample forms or contracts provided by the name of the software are examples only. Please check with your attorney or your state self-storage association as to the legal and proper content of any forms or contracts you may use with your business operations. We disclaim any representation or warranty as to the legal or factual accuracy of these sample forms and documents. Well, that's a lot of legalese. Let me tell you what that means in plain English. In plain English, it means there's no guarantee this software complies with Kansas law. If you use this software without making sure it complies with Kansas law, you alone are responsible for the consequences. So the critical thing here to know is just because you download something, you install something, and it spits stuff out of your computer, it doesn't necessarily mean it's going to comply with Kansas law. You're going to have to make sure that happens. And that's the reason for that is really simple. There are 50 plus different laws that govern self-storage across the country. The vendors of various kinds of technology that you may use send one out, but they send the disclaimer so you'll know you may have to fine tune this for your particular state. And they often put special customizing features on the software. That's how you go about making sure that these things meet your requirements. Because if you fail to do so, as I said, bad things happen when you don't do that. You cannot rely on the technology to ensure that you are complying with Kansas law. That's the bottom line. And when I said to you, I was talking about things I'm seeing in greater frequency. That's many of the legal issues that are coming up. People who've discovered that they were relying on things and they hadn't checked out in advance that they were in fact complying with local law. That's what you need to do. You may remember when you were a kid, the picture of Smokey the Bear telling you only you can prevent forest fires. Well, think of me as Stanley the Bear telling you only you can comply with Kansas law. It's not up to your vendor. It's not up to the software. It's not up to KSSOA. Only you can make sure that's occurring. So how do we comply? Well, it all starts with the rental agreement, just like it does if you had a paper business. Kansas law tells you exactly what has to be in it. You should have received from Brian a handout that has some more detailed information about these kinds of things that I can't put on the screen. There's one called, Does My Rental Agreement Comply with State Law? That will give you a more detailed look at what you need to have in that rental agreement. But those things need to be in place, whether you're dealing electronically or whether you're doing something in paper form. The most common problems I see across Kansas with leases, rental agreements, are first, they do not have the mandatory language required for the lien, to notice of the lien, and it in bold print. If you lay this template next to your lease and you don't have at least one bold-faced paragraph in your contract that talks about the operator's lien, then you're not in compliance with Kansas law, and you risk getting into real trouble if you have a lien sale regardless. So make sure that's the case. The other thing, believe it or not, that I see sometimes is the rent space. The amount of the rent is left blank, and the amount of the monthly late charge is left blank. Remember, if you don't have those things spelled out in the contract, they're not a default, and therefore you can't have a lien sale if somebody fails to pay. So you've got to make sure those things are recorded in your rental agreement. whether it's online or whether it's a paper copy. You've got to make sure those things get done. Now, there is some good news. The good news is that these can be electronic. And I know you spent a lot of time today talking about touchless systems and electronic and technology and various things to make this a much smoother process. And that's great. Kansas law, we'll talk about this in a minute. Kansas law is fully on board with that, but you still have to comply with that same old 40-year-old statute that we've always had. And that is what is critical here, because if you don't, as we've said, bad things happen. So even though you've got the best rental agreement in the world, sooner or later somebody will fail to pay. And usually when that occurs, it means you've got to have a lien sale. Nobody likes to have them, but they actually are a gift from the legislature. They are a quick way to get bad tenants out, perhaps get a little bit of money, and move on and get back into productive service. Kansas law tells you exactly what you have to do to have a lien sale. All I can say is do it. You must follow those procedures. In the handout that Brian sent you, you'll also find a Kansas lien sale timeline, which goes into this in much more detail than I can put on the screen or cover here in the few minutes we have together. The bottom line is there's a straightforward process, follow it, and you should be fine. In oversimplified fashion, here's what the process looks like. It all starts with a default. That's a failure to do something a tenant is supposed to do. Normally that's pay rent. So that's a default. That's where it all begins. If someone hasn't defaulted, don't think about a lien sale because you have no basis for it. As soon as possible thereafter, now that's up to you how quickly it happens, but soon thereafter you send the first default letter. And in Kansas, that can go by U.S. mail, first class mail, or by email. Yes, it has to go by both if the tenant gives you an email address. So it goes by mail and by email. You wait 8 or more days and send a second default letter. Now, if anything jumps the tracks in this process for a lien sale, it'll be that second default letter. Why? Because Kansas law is very specific about what has to be in that letter. It has to tell the tenant the stored property is subject to a lien. It has to tell the amount that's due as of the day you send the letter and when additional charges will come due, a demand for payment at least 11 days or no sooner than 11 days after you send the first letter, a statement that unless that amount is paid, the property will be sold after a specified date, and then where and how the tenant can contact the operator about his or her property. So that is the lien sale process from 10,000 feet up. Now, take a look at those 5 things. If your system is spitting out more than 2 default letters and running an ad, I should have talked about the ad. If it's doing more than that, then your system is not linked up with Kansas law, lined up with Kansas law, and you may not be in compliance. And of course, 45 days must go by before the lien sale. If you're doing less than this, you may have a real problem because you may not be sending out all the notices you need to. I sometimes hear from people who will tell me, I'm trying to have a lien sale, and I'll say, okay, well, what notices have you sent out? And sometimes they will tell me 3, 4, 5 different things they've sent out. And I come back to them and say, you realize there are only 2 things you need in an ad: a first notice, a second notice, and a published ad, and that's it. So anything else that comes spitting out of the computer, you really don't need. And if the computer system had been tailored to Kansas law, it wouldn't be giving you all this extra stuff. But in any event, that's the procedure in the overview. Remember, the ad you run once, not multiple times, once, at least 7 days before the sale. I've put on here, 7 days before the sale, and the lien sale must be 45 days after the default. So that is the process that you want to look at. Make sure your process, even if it's automated, make sure it is complying with the law. Now, I sometimes get this question: if I send notices by email, which you may be doing if you're becoming a more, if your business is relying more on an electronic template for doing business, do I still have to send them by regular mail? The answer is yes. Under Kansas law, a notice of default, second notice of default, always goes by U.S. mail. It also goes by email if the tenant has given you an email address. But even if the tenant gives you an email address, it still always goes by U.S. mail to the last known address. Remember too, that if you're selling an automobile, that you're using going through the Department of Revenue and obtaining a title or the paperwork to obtain a title, just remember that one still has to go the old-fashioned way by restricted delivery mail, which is sort of certified mail on steroids. But the bottom line is that's the one exception to what I've mentioned to you. The other one I get is, can I have an online auction? I think the answer in Kansas is probably yes, and I'm fairly certain that's the correct answer. I say probably because there's nothing in Kansas that expressly permits the use of an online auction, and there's also nothing that expressly prohibits the use of an online auction. Instead, the statute simply says your sale must be commercially reasonable. And that simply means, is this the way a merchant in these types of goods might reasonably sell them? Given the proliferation of online sales, online auction sites, I think that the state of Kansas, if it addressed it, would likely say, well, yeah, that's commercially reasonable. Be aware, however, that at least on a couple of occasions I'm aware of, the state of Kansas has had the opportunity to expressly put that in the statute, and they have not done so. Now, I don't know whether their refusal was specific to that point or not, but be aware of that it isn't expressly permitted. It's also not expressly prohibited. And based on the commercially reasonable language for our sales, I think we can probably do that. What about the ad? I get the question, do I have to publish an ad? You know, I use an electronic business model. Do I still have to publish an ad? Or I'm doing an online auction instead of a live one. Do I have to have an ad? I'm going to do a private sale instead of a public sale. Do I need to have an ad? The answer is right now in Kansas, there is no exception. If you're going to have a lien sale, you must publish an ad in the newspaper in the general jurisdiction where you're going to have the sale. We don't have any exclusions, any exceptions at this point. That becomes kind of tricky because, I mean, stop and think about that for just a second. You're a 21st century business, and publishing notices in the newspaper is a 19th century way of doing business. So now we're even in another century trying to do business here, but it's required. And until this legislature changes the law, we're stuck with this kind of a provision. The ad is becoming harder to run in Kansas because there aren't as many local newspapers as there used to be. They're kind of becoming harder to find. So what kind of newspaper do I have to use in order to publish my ad for a lien sale? Well, generally speaking, it has to be a newspaper. That seems like a given, but that has a special meaning in Kansas. If it's a newspaper, it has to have news. Okay, it can't just be the local shopper. It must have a news component to it. It doesn't have to be anything like the Kansas City Star, but it must at least have some news stories of general import or general interest. But it doesn't have to have a lot, but it must have some. It must publish at least once per week. It does not have to be a daily newspaper. It can, as long as it publishes once per week. Has to be delivered by the post office as a periodical and not as some sort of private newsletter. So that's pretty standard. The newspaper must have been in business for at least 1 year. And it must have paid subscribers in your county. Can't be a free handout. It has to have paid subscribers. And ideally, it's a newspaper published in your county. But if you're in a county that doesn't have a newspaper being published in the county, as long as there is in general circulation in your county and is published in the state of Kansas, then you should be fine. So again, you can't go in the local shopper because there's no news and there are no paid subscriptions. It also can't be on a website because that's not a newspaper. So from now on, for at least for the time being, we're going to have to make use of this. That ad gets run where the sale is to be held, not necessarily where you're located, where you're going to hold the sale. Here's my recommendation to you. If you've got questions about where to publish your ad, call your local municipal clerk, call the local clerk of the district court at your county seat, or the clerk of the probate court in your county seat. Ask them where they publish legal notices, and they're going to give you the name of a paper, and you really can't go wrong if you simply publish in the same paper that they use. That will get you to a paper that works. Now I know, and you may have talked about this earlier in the meeting today, I know that in 2020, House Bill 2454 went before the Kansas legislature to make some changes, some upgrades to the Kansas Self-Storage Act. It did not pass. It died in the Senate. I will tell you, looking at the legislative history on that, the strongest opponents to the changes to this law appear to have been from newspaper publishers across the state of Kansas. Why? Because they don't want to lose the revenue. That's why. And so they pushed hard on this change. So here's a thought. If you want to make it easier to get that bill through the legislature in the next session, maybe you drop out the portion of it that says we can publish on a website. That would eliminate the pushback you got from newspaper publishers. On the other hand, you're still going to have to pay them to run an ad in newspapers that fewer and fewer people are reading all the time. But in any event, your major pushback to House Bill 2454 came from newspaper publishers. That was the problem. Now, the good news as we deal with technology is that you can do it on things on your smartphone now. You can do all kinds of things that we used to just have to do on paper with pen and ink. And that's fine. Kansas law could not be clearer, same with federal law, that an electronic contract and an electronic signature is valid and enforceable for all purposes in the state of Kansas. So that's fine. We're free to do business that way. And nothing is going to void your contract or void a signature just because it's electronic as opposed to being on paper. But understand, when you start under Kansas law, and it's similar under federal law, when you start using electronic documents and electronic signatures, there are some potential pitfalls that you need to be aware of and be thinking about. So for example, you cannot force a person to conduct an electronic transaction against their will. Someone cannot walk into your facility if you do business on paper and say, well, I insist on doing this by electronically. Well, they can't force you to do that. By the same token, if somebody says, I want to rent a unit, and you say, we do it exclusively online, I can't force them to do that against their will. Now, can I refuse to rent to them if they don't want to do it electronically? I don't see anything in the law that would prevent that, but nobody can be forced to do something electronically against their will. That's just what Kansas law says. Also, electronic rental agreement is not enforceable unless the tenant can print and store the rental agreement. So if you're going to do business online, you're going to do it electronically, the tenant must have an ability to either store it or print it. Notice the law does not say have access to it. It says store it or print it. So you're going to have to make sure that somehow, once that contract is entered into, the tenant can have, in essence, his or her own copy of it. Otherwise, the contract will not be enforceable in Kansas. And can you understand why that's important? You don't want to have a lien sale and then have these people say to you, well, you didn't have a valid rental agreement. Well, why? Because I wasn't able to print it. I wasn't able to store it. And they're right. Your contract would not be valid at that point. So you've got to be really mindful of that and careful. you understand that under Kansas law, you may have to prove that an electronic signature is attributable to the person who purported to sign. In other words, what are you going to do if the tenant says, well, yeah, you've got a contract that appears to have been signed in my name, but that's not me? Well, it's going to fall to you through the use of your software, through a variety of means, to be able to prove the person who signed this is in fact the person whose name is represented there. I think earlier in some of the discussions that I overheard with in the panel, there may be some pretty interesting ways to do that nowadays through technology, which is great, but understand that's a potential pitfall you may have to deal with. You must give the tenant an opportunity to correct any errors before he or she submits the agreement or the signature. So if a tenant finds, oops, I got the last known address, I got the wrong, I reversed a couple of digits. Before he enters the contract or she enters the contract, you've got to give them an opportunity to change that and correct it before it happens. So that's another issue. And then finally, the tenant has to have a moment of truth under Kansas law. The tenant must have an opportunity where they make a decision to go forward or not go forward with the contract. And they must understand that if I hit send or whatever the equivalent button would be, we will have formed an enforceable contract. So you've got to make sure that however your sequence goes through whatever technology you're using, you've got to make sure there is a moment of truth where the tenant can say, yes, in fact, this is what I want to do. And then you have an electronic contract, which again is fully enforceable in the state of Kansas. Now, not only does the electronic nature of the contract bear on this, but also remember, we still have to comply with all of the Kansas Self-Storage Act. Okay, I just talked about the fact that operator's lien notice has to be in bold print. Well, even if you're doing this online, you'd better make sure that what's on the screen and what the tenant can store has the notice of the operator's lien as required by the statute, and it better be in boldface print. So make sure you do that. The other thing, which is not required by the statute, but it's required by other portions of Kansas law. Many of your contracts, and certainly the model rental agreement, have what we call exculpatory clauses. That's just lawyer talk for releases and indemnities, things that say we're not going to be liable if. Remember that in Kansas, those things have to be conspicuous in order to be enforceable. You can't bury those things in the fine print. So whatever you're doing, if you're doing it online, it pops up on the screen at a kiosk and they're looking at these things, make sure that those things are conspicuous in some way. Otherwise, you run the risk that they won't be you can't rely on them when you need them. So whatever you're doing, make sure that's the case. Also, we all know about military personnel. You have a number of bases in Kansas, so this is very important across the state of Kansas. Remember, of course, that if you have a person who is on active military duty or within 90 days of active military duty, even if they're in default, you cannot have a lien sale unless you have either a court order or you have a waiver of rights under the Service Members Civil Relief Act, which is perfectly enforceable and can be done electronically. However, remember that to be enforceable, two things. This waiver must be in a document separate from the rental agreement, number one. Number two, that waiver must be in 12-point type. So while you may not be able to control for that on a smartphone, when it's on a computer, and certainly when they're able to store it and to print it, you need to make sure that that thing's going to pop out in adequately sized type. So again, even though you're electronic, we're still having to deal with these sort of antiquated in paper requirements. The other thing you need to remember, if you're doing business online, then most likely you're collecting a lot of consumer information electronically, and that poses some issues too. Under Kansas law and under federal law, you have a duty to protect consumer information, personal information. Well, what does that mean? In the state of Kansas, that means any kind of document or data that it would allow someone to pair a person's name with their social security number, driver's license number, or financial credit card or debit card number, okay? It's not any of those things by themselves, but anything that would allow you to link a specific name with a specific number. That's what is considered personal information in Kansas, and we have a duty to protect that. If for any reason, electronically, you felt like your system had been breached or hacked, what do? Well, under Kansas law, your duty is to promptly investigate. Investigate what? You need to be able to answer this question. Is it likely that personal information has been or will be used? That's what you have to answer. You've got to get involved and investigate and figure that question out, because if the answer is yes, it's likely, okay, not that it has, that it's likely, then you must give notice without unreasonable delay to your customers. You've got to give them a chance to protect themselves from the adverse consequences that might flow from the use of that information. Now, that's if you're hacked. We also know that over time, we used to talk about, when do you purge old files? How long do you keep tenant information around? All that kind of stuff. Well, we also have a duty in Kansas to make sure that when we dispose of personal information, documents containing personal information, we have to make sure that it's destroyed in a way that is unreadable or undecipherable through any means. We've got to get rid of it completely. Now, when you're dealing with paper documents, that's pretty easy. You simply run them through you run them through a shredder, you burn them, they go to an acid bath, whatever it may be, you destroy them. Electronic data is interesting. Excuse me. It's very easy to collect. It's very easy to store, and it's horribly hard to get rid of. Why? Because even if you delete it on your database or in whatever program you may be using, it still may reside on a hard drive. It may reside on some sort of external storage mechanism, whatever it may be. You've got to make sure, if you're going to dispose of this information, that it's disposed in a way completely and can't potentially reach someone who may be able to use it adversely to the customer. Be particularly mindful if you're disposing of old computer equipment. All kinds of retrievable data may be hiding on the hard drive. So please, you may want to consider looking at one of the professional companies that will wipe clean those hard drives before you turn loose of the document itself. Also, if you're doing business electronically, you're probably using credit cards, debit cards more and more than perhaps you used to. Hang on here. May I charge a user fee for people using a credit or debit card in the state of Kansas? The answer is no. Kansas is one of half a dozen states across the country that says a surcharge for the privilege of using a credit card is unlawful in the state of Kansas. So don't do that. The other question that comes up sometimes is, I want to go to an exclusively cashless business model. Can I do that? Well, the answer is yes. There's nothing in federal law or in Kansas law that requires you to accept cash. You're free to go to a credit card only kind of platform if you choose. The only thing you might be aware of is there are some people of a particular political stripe who think that's anti-poor people. And therefore they push back and call it discrimination. And some of the more, what we might used to call liberal jurisdictions, progressive jurisdictions, some cities and things have said, no, you have to accept cash so that you can accommodate people who are unlikely to have a credit card. And I'm not aware of any of those in the state of Kansas, but nevertheless, there are some around the country. But as of now, if you said in COVID times, I'm going to do things exclusively by debit card or by credit card, you would be fully within your rights to do so. So That said, that's a quick overview of the law. I'll open it up to questions, and let me just move this down and hopefully,
We've got a couple questions in the Q&A box here.
okay.
Shauna's asking, she has a deceased client and the personal property has been basically abandoned with no next of kin. What is the next legal procedure?
Okay, if you have a deceased tenant and you can't identify the next of kin, was that the idea?
Yes, that's correct.
Okay, yeah, I would probably,
There is no next of kin, so she knows that
I'm sorry, I didn't hear.
she knows there is no next of kin.
There is no next of kin. Probably there, I would consider having a lien sale and get rid of it.
And then
Because in Kansas, we actually can have a lien sale for dead people, believe it or not.
okay, Kevin asks, can the tenant's copy of the contract be stored electronically, like say via cloud? Does that qualify as stored?
Yes, from what I've read, that would qualify. That would qualify.
And what steps can a storage operator take to terminate the rental agreement when the tenant breaches the contract by disobeying posted rules and regulations?
Yeah, to terminate a contract is different from a tenant who's in default and hasn't paid and you move on to a lien sale. That is really governed by Kansas law, and the law is very similar to what you would use to evict someone from an apartment. You basically, it starts with sending them a notice saying, I, the landlord, am terminating your tenancy. Depending on the circumstances, that what kind of notice must be given, the notice in the contract, that sort of thing will govern. If they don't leave, then you have to go file some sort of lawsuit, an eviction suit to move them out, and have the sheriff put you back in possession of the unit.
And then Ed's asking, is text messaging legal in Kansas in terms of communication?
Yeah, that's not governed by Kansas law. That's governed by federal law, and that has been prescribed. And I've looked at it in recent months, but not enough to give you a definitive answer today. The answer is be very careful with it. There are some things that are prohibited without specific customer approval in advance, some things that are not, and beyond that, I really don't want to go. But the answer is it's a federal question, not a Kansas question.
Okay. And policy and procedures and terms and conditions for websites, do you have access to something like that, or?
Do I have access to those?
Yeah, is that something that's required, I guess, for all our self-storage websites? And do we?
Terms and conditions, well, certainly anything that's in your rental agreement has got to be there for the customer to see and to read and to be able to print and store when it comes out.
Brian, if I could chime in there, they ought to make sure that their website is ADA compliant. That is a huge thing right now that's going on in the storage industry. And there's a lot of attorneys and their clients that are going around. It started in New York, it went to Florida, it's coming around into Texas. But there's some very specific things that you have to do to make your website ADA compliant. For example, when you hover your cursor over a photo, your alt messages or your alt tags need to describe what that photo is, or be able to feed into a widget that allows somebody who's visually impaired. It's the visual impairment those are the attacks on storage right now.
Okay.
Good word.
And there's a unit that has suffered water damage. That it has been repaired. The tenant's items have some mold damage. The self-storage facility offered remediation. The customer has not responded. They're concerned about the items staying in the building because they're moldy, I guess. Yeah, it's still moldy. It's not been remediated. What do they do?
Yeah, it's and again, I need to give you the disclaimer here that this is not a place for me to give you legal advice. Some of these are so specific that frankly, we can't ask the questions we need to ask in this format. But I would generally say that's where you're going to rely on the language of your rental agreement. And certainly you have the ability to protect the facility. And if I had something in a unit that was causing danger to whatever to the rest of it, and I've got a tenant who won't respond, boy, I'd be inclined to document it the way I would for things that have no commercial value and protect the building.
Okay.
Now, that said, I don't know the specifics of the case you just mentioned, but generally speaking, I would be looking at it as protecting the facility.
Okay. And then okay. I think that's all the questions I have here. Are there any other questions? Anyone else? Okay. Well, thank you, Stan. Thank you very much.
Thanks,
Thank you
Dan.
as always for having me. I appreciate it and wish you all the very best. Again, I apologize for the snafu at the beginning. I'm not sure what happened to my presentation, but glad we were able to get it back. Thanks, everybody.
Thank you. Okay. Well, we have now reached the conclusion of our annual conference. I want to thank you all for attending and thank you to the storage group for virtually hosting our meeting. We want to thank our sponsors this year as well, Argus Self-Storage Advisors, Green Steel Buildings, U-Haul, and Watertight Roofing. Your support really keeps us going. We will have recordings available to all our paid members in the next day or two. Thanks again to everyone, and remember to stay safe out there, stay strong, stay positive, and until next time. Goodbye. Thank you.
Thanks,
Thanks,
Brian.
everyone.